Crimes against persons. What are the essential elements of parricide as the relationship? The relationship of the offender with the victim must be 1. Legitimate, except in the case of parent and child; 2. In the direct line; and 3. By blood, except in the case of a legitimate spouse. Explain and illustrate the stages of execution of the crime of homicide, taking into account the nature of the offense, the essential element of each of the stages of execution, and the manner of committing such intentional felony as distinguished from felony committed through reckless imprudence. 2012. Elements of the crime. Homicide as an intentional felony has 3 stages: attempted, frustrated, and consummated. In whatever stages homicide is committed, intent to kill must be established for being an indispensable element thereof. However, if the victim died as a consequence of wounds caused by an act committed with malice, intent to kill is conclusively presumed, and the crime committed is consummated homicide. Because of this conclusive presumption, lack of intent to kill is not a defense in consummated homicide. Note: in consummated homicide, the accused may prove lack of intent to kill for purpose of appreciating the mitigating circumstance of praeter intentionem. But if the victim did not die as a consequence of wounds caused by an act committed with malice, intent to kill must be established beyond reasonable doubt. If intent to kill is proven, the crime committed is frustrated or attempted homicide. If intent to kill is not proven, the crime committed is physical injuries. Thus, lack of intent to kill is a defense in attempted or frustrated homicide. Nature of the crime. If the offender with intent to kill attempted to inflict or inflicted non-mortal wounds upon the victim, he already directly commenced an overt act to commit homicide. Hence, the crime committed is attempted homicide if he failed to inflict mortal wounds upon the victim by reason of some cause or accident other than his own spontaneous desistance. If the offender with intent to kill inflicted mortal wounds upon the victim, he already performed all acts of execution which would produce the homicide as a consequence. If that is not produced despite the mortal character of the wounds due to cause independent of the will of the offender, the crime committed is frustrated homicide. If death is produced, the crime committed is consummated homicide. In this situation, all the elements necessary for execution and accomplishment of homicide are present if the victim dies due to the wounds inflicted by the offender with the intent to kill. Intentional felony and culpable felony. Homicide, regardless of stages, must be committed with malice, general intent, and intent to kill, specific intent. But if there is no intent to kill and evil intent, the offender is liable for culpable felony if the victim dies or was injured as a result of the recklessness of the former. If there is no intent to kill, evil intent and recklessness on the part of the accused, he is not liable for his intentional act, which caused the death of or injury upon the victim because of the exempting circumstance of accident. Cite 5 factors in ascertaining intent to kill. 1. Means used by the malefactors. 2. Nature, location, and number of wounds sustained by the victim. 3. Conduct of the malefactors before, during, or immediately after the killing of the victim. And 4. Circumstances under which the crime was committed. 5. Motive of the offender. And 6. Words he uttered at the time of inflicting the injuries on the victim. De Guzman, Jr. versus People. Vilostas went to a nearby videoke bar to buy cigarettes. Once inside the bar, he was stabbed by Olarte, Aryo, and Pasquin on different parts of his body. When Vilostas was rushed to the hospital, where he was treated, and the doctors testified that all the injuries suffered by Vilostas were fatal and would cause his death were it not for the timely medical attention given to him, is Olarte, Aryo, and Pasquin guilty of frustrated homicide? Answer: yes. All the elements of frustrated homicide are present. First, their intent to kill is manifested by the weapon used, which is a pointed sharp object. Second, the victim suffered numerous fatal wounds, but he did not die due to the timely medical assistance given to him. Third, none of the qualifying circumstances for murder is present. Olarte versus People. Leyva was waylaid and shot with firearms by the group of Etino. Etino only fired a single shot at close range, but did not hit any vital part of the victim's body. It appears that he did not sustain any fatal injury as a result of the shooting, considering that he and his companions even went in pursuit of petitioner after the incident. RTC found petitioner guilty beyond reasonable doubt of the crime of frustrated homicide, to which the CA affirmed. Is the ruling correct? Is the use of firearm sufficient to prove intent to kill? No. It cannot be reasonably concluded that petitioner's use of a firearm was sufficient proof that he had intended to kill the victim. After all, it is settled that intent to kill cannot be automatically drawn from the mere fact that the use of firearms is dangerous to life. Rather, animus interficendi must be established with the same degree of certainty as is required of other elements of the crime. The inference of intent to kill should not be drawn in the absence of circumstances sufficient to prove such intent beyond reasonable doubt. When the intent to kill is lacking, but wounds are shown to have been inflicted upon the victim, it is in this case the crime is not frustrated or attempted homicide but physical injuries only. Etino versus People. State the rules for the application of the circumstances which qualify the killing to murder. 1. That murder will exist with any of the circumstances. 2. Where there are more than one qualifying circumstance present, only one will qualify the killing, with the rest to be considered as generic aggravating circumstances. 3. That when the other circumstances are absorbed or included in one qualifying circumstance, they cannot be considered as generic aggravating. 4. That any of the qualifying circumstances enumerated must be alleged in the information. On his way to buy a lotto ticket, a policeman suddenly found himself surrounded by 4 men. One of them wrestled the police officer to the ground and disarmed him, while the other 3 companions, who were armed with a hunting knife, an ice pick, and a balisong, repeatedly stabbed him. The policeman died as a result of the multiple stab wounds inflicted by his assailants. What crime or crimes were committed? All the assailants are liable for the crime of murder, qualified by treachery, which absorbed abuse of superior strength, as the attack was sudden and unexpected, and the victim was totally defenseless. Conspiracy is obvious from the concerted acts of the assailant. Direct assault would not complex the crime, as there is no showing that the assailants knew that the victim was a policeman. Even if there was knowledge, the fact is that he was not in the performance of his official duties, and therefore there is no direct assault. Note, the suddenness of the attack would not by itself suffice to support a finding of treachery. However, where proof obtains that the victim was completely deprived of a real chance to defend himself against the attack, as in the instant case, thereby ensuring its commission without risk to the aggressor and without the slightest provocation on the part of the victim, the qualifying circumstance of treachery ought to and should be appreciated. Verily, what is decisive is that the attack was executed in a manner that the victim was rendered defenseless and unable to retaliate. People of the Philippines versus Soriano. Degami concealed Bugna's body and the fact that he killed him by setting Bugan's house on fire. What crime or crimes did Degami commit? Separate crimes of murder and arson. A, B, and C are members of SFC fraternity. While eating in a seaside restaurant, they were attacked by XYZ members of a rival fraternity. A rumble ensued, in which the above-named members of the 2 fraternities assaulted each other in confused and tumultuous manner, resulting in the death of A. As it cannot be ascertained who actually killed A, the members of the 2 fraternities took part in the rumble and were charged for death caused in a tumultuous affray. Will the charge prosper? No, the charge of death caused in a tumultuous affray will not prosper. In death caused by tumultuous affray, under Article 251 of the RPC, it is essential that the persons involved did not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. In this case, there is no tumultuous affray, since the participants in the rumble belong to organized fraternity. State the effects of the reclassification of rape into a crime against person. 1. The procedural requirement of consent of the offended party to file the case is no longer needed because this is now a public crime, unlike when it was still classified as a crime against chastity. And there is now an impossible crime of rape because impossible crimes can only be committed against persons or property. Note: resistance is not an element of rape, and the absence thereof will never be tantamount to consent on the part of the victim. Besides, in rape committed by a relative such as a father, as in this case, moral influence or ascendancy takes the place of violence. People versus Bundakilio. A rape victim has no burden to prove that she did all within her power to resist the force or intimidation employed upon her. As long as the force or intimidation present, whether it was more or less resistible, is beside the point. Though a man puts no hand on a woman, yet if by the use of mental and moral coercion and intimidation the accused so overpowers her mind out of fear that as a result she dared not resist the dastardly act inflicted on her person, accused is guilty of the crime imputed to him. People of the Philippines versus Gabriel. AJ, a medical student, was a boarder in the house of Mr. and Mrs. M, who had a good-looking 25-year-old retarded daughter with the mental age of an 11-year-old girl. One day, when the couple went out, Perlita, the retarded daughter, entered AJ's room, came near him, and started kissing him. He tried to avoid her, but she persisted. They had sexual intercourse. This was repeated every time Perlita's parents were out until Perlita got pregnant. Mr. and Mrs. M filed a complaint of rape against AJ, who claimed that it was Perlita who seduced him, that Perlita was intelligent, clearly understood what she was doing, and that since Perlita was already 25 years old and did not herself file the complaint, her parents had no personality to file the complaint for rape. How would you resolve the case? The contention of AJ cannot be sustained. Sexual intercourse with Perlita, who is a mental retardee, older 25 years old, but with a mental age of 11 years old, girl, is rape. She is the same class as a woman deprived of reason or otherwise unconscious. Since she is suffering from an incapacity, being incompetent on account of her mental age, the parents have the right to file the complaint for rape. Note: the crime of rape is committed when the offended party is deprived of reason or is otherwise unconscious. Physical force, threat, or intimidation is not necessary, for the simple reason that an unconscious and extremely intoxicated woman cannot freely and voluntarily give her consent to engaging in sexual intercourse. People versus Kaga. Triple X, then a 10-year-old boy, requested his mother to pick up Ricalde at McDonald's, Bel Air, Santa Rosa. Ricalde, then 31 years old, is a distant relative and textmate of Triple X. After dinner, Triple X's mother told Ricalde to spend the night at their house as it was late. He slept on the sofa while Triple X slept on the living room. It was around 2 o'clock a.m. when Triple X awoke, as he felt pain in his anus and stomach and something inserted in his anus. He saw that Ricalde fondled his penis. When Ricalde returned to the sofa, Triple X ran toward his mother's room to tell her what happened. He also told his mother that Ricalde played with his sexual organ. Triple X's mother armed herself with a knife for self-defense when she confronted Ricalde about the incident, but he remained silent. She asked him to leave. Is Ricalde guilty of the crime of rape? Yes. All the elements of rape is present in the case at bar. Rape under the second paragraph of Article 266-A is also known as instrument or object rape, gender-free rape, or homosexual rape. Any person who, under any of the circumstances mentioned in paragraph 1 hereof, shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument of or object into the genital or anal orifice of another person. The grave man of rape through sexual assault is the insertion of the penis into another person's mouth or anal orifice, or any instrument or object into another person's genital or anal orifice. Ricalde versus People. AAA, a 67-year-old woman, fast asleep, when Bill covered her mouth, threatened her with a knife, and told her not to scream because he will have sexual intercourse with her. Thereafter, he removed AAA's underwear. However, his penis was not yet erected. so he toyed with Triple A's sexual organ by licking it. He then made his way up and tried to suck Triple A's tongue. Once done, Bill held his penis and inserted to Triple A's vagina. In his defense, Bill argued that during the entire alleged incident, Triple A never reacted at all. Is Bill guilty of rape? Yes. Bill is guilty of rape. Triple A was already 67 years of age when she was raped in the dark by Bill, who was armed with a knife. A woman of such advanced age could only recoil in fear and succumb into submission. In any case, with such shocking and horrifying experience, it would not be reasonable to impose upon Triple A any standard form of reaction. Different people react differently to a given situation involving a startling occurrence. People versus Justiva. One night, while Triple A was sleeping, Triple X hugged her and kissed her nape and neck. He then undressed Triple A and went on top of her and held her hands. Afterwards, he parted Triple A's legs and then tried to insert his penis into her vagina. Triple A's penis touched Triple A's vagina, but he stopped as soon as Triple A's cry got louder. He then threatened Triple A not to disclose the incident. What crime was committed? Triple X is guilty of attempted rape. Without showing of such carnal knowledge, Triple X is guilty only of attempted rape. Mere touching cannot be considered as slight penetration. Since Triple X did not succeed in inserting his penis in Triple A's female organ, he cannot be convicted of consummated rape. Slightest penile penetration is necessary. People versus Pareja. Chris and his wife employed Triple A and Triple B to help them in their plastic and glassware business during a town fiesta in La Union. After fixing the wares in order for display, they went to bed inside the tents. Less than an hour passed. Triple A was awakened with Cruz on top of her, mashing her breast and touching her vagina. Triple A fought back and was able to free herself from Cruz. She ran out to seek for help. Is Cruz guilty for the crime of attempted rape? No. Cruz is not guilty of attempted rape. The intent to commit rape must be inferred from overt acts directly leading to rape. In embracing Triple A and touching her vagina and breast did not directly manifest his intent to lie with her. The lack of evidence showing his erectile penis being in the position to penetrate her when he was on top of her deterred any inference about his intent to lie with her. At most, his acts reflected lewdness and lust for her. Cruz versus People. Crimes against personal liberty and security. Aniban and Lirio are neighbors. Lirio entered the house of Aniban, laid down beside the infant child of Aniban, and began chatting with her. Lirio then told Aniban that she would take the infant outside to bask him under the morning sun, but the latter refused. A few minutes later, Aniban realized that Lirio and her child were no longer in the house. After searching, Aniban found her infant child, Lirio's boyfriend, and Lirio on board a vessel. Lirio, together with co-accused, were charged with kidnapping of a minor. Are they liable as charged? Yes. The following are the elements of kidnapping under Article 267, Paragraph 4 of the Revised Penal Code. The offender is a private individual, number 1. Number 2, he kidnaps or detains another, or in any other manner deprives the latter of his or her liberty. 3. The act of detention or kidnapping is illegal. And 4. The person kidnapped or detained is a minor, female, or a public officer. Norada and Siva made a plan to kidnap Ray Troc. On the appointed day, accused Villanueva fetched Reggie Pasil and Ray Troc in the house of Pasil in Valladolid, but only Reggie Pasil came. Ray Troc remained in the house of Reggie Pasil in Valladolid. The non-appearance of Ray Troc made them change their plan. They decided to just kidnap Reggie Pasil, as they were convinced that Ray Troc will pay ransom for his release. However, no ransom was made and they have killed Pasil. Is there kidnapping? None. The essence of the crime of kidnapping is the actual deprivation of the victim's liberty, coupled with the intent of the accused to effect it. It includes not only the imprisonment of a person, but also the deprivation of his liberty in whatever form and for whatever length of time. The totality of the prosecution's evidence failed to sufficiently establish the offense of kidnapping in this case. There was no concrete evidence whatsoever to establish, or from which it can be inferred that accused and his cohorts intended to actually deprive the victim of his liberty for some time and for some purpose. There was also no evidence that they have thoroughly planned the kidnapping of the victim. There was lack of motive to resort in kidnapping the victim, for they were bent to kidnap his friend. Truck. People versus Norada. Sexy boarded a taxi on her way home from a party. Because she was already tipsy, she fell asleep. Pogi, the taxi driver, decided to take advantage of the situation and drove Sexy to a deserted place where he raped her for a period of 2 weeks. What crime did Pogi commit? Pogi committed the special complex crime of kidnapping and serious illegal detention with rape. All the elements of kidnapping and serious illegal detention are present. Pogi, a private individual, kidnapped and detained Sexy by bringing her to a deserted place. Said detention is illegal and is serious because it lasted for more than 3 days, and the victim is a female. The special complex crime of kidnapping and serious illegal detention with rape resulted because Sexy, the victim of the kidnapping and detention, was raped as a consequence of the detention. Article 267, last paragraph of the RPC. Since it is a special complex crime, regardless of the number of times the victim had been raped, there is only a single, indivisible offense of kidnapping and serious illegal detention with rape. While walking alone on her way home from a party, Mildred was seized at gunpoint by Felipe and taken on board a vehicle to a house some distance away. Felipe was with Julio, Roldan, and Lucio, who drove the tricycle. At the house, Felipe, Julio, and Roldan succeeded in having sexual intercourse with Mildred against her will and under the threat of Felipe's gun. Lucio was not around when the sexual assault took place, as he left after bringing his colleagues and Mildred to their destination, but he returned every day to bring food for 5 days. Felipe, Julio, and Roldan kept Mildred in the house and took turns in sexually assaulting her. On the 6th day, Mildred managed to escape. She proceeded immediately to the nearest police station and narrated her ordeal. What crimes did Felipe, Julio, Roldan, and Lucio commit, and what was their degree of participation? Felipe, Julio, Roldan, and Lucio are liable for the special complex crime of kidnapping and serious illegal detention with rape. It was sufficiently proved that the 4 accused kidnapped Mildred and held her in detention for 5 days and carnally abused her. Since it is a special complex crime, no matter how many times the victim had been raped, the resultant crime is only one kidnapping and serious illegal detention with rape. The composite acts are regarded as a single indivisible offense with only one penalty. It is illegal detention and not forcible abduction, since it was evident that the intent was to detain the victim. As to the degree of their participation, Felipe, Julio, Roldan, and Lucio are all liable as principals. There was implied conspiracy as they acted toward a single criminal design or purpose. People versus Mirandilla. Although Lucio was not around when the sexual assaults took place, there is complicity on his part, as he was the one who drove the tricycle at the time the victim was seized, and he returned every day to bring food and report the news to his conspirators. Paz Masipag worked as a housemaid and yaya of the 1-week-old son of the spouses Martin and Pops Creepot. When Paz learned that her 70-year-old mother was seriously ill, she asked Martin for a cash advance of 1,000, but Martin refused. One morning, Paz gagged the mouth of Martin's son with stockings, placed the child in a box, sealed it with masking tape, and placed the box in the attic. Later in the afternoon, she demanded 5,000 as ransom for the release of his son. Martin did not pay the ransom. Subsequently, Paz disappeared. After a couple of days, Martin discovered the box in the attic with his child already dead. According to the autopsy, the child died of asphyxiation barely 3 minutes after the box was sealed. What crime or crimes did Paz commit? Paz committed the special complex crime of kidnapping with homicide under Article 267, as amended by RA 7659, Under the law, any person who shall detain another or in any manner deprive him of liberty, and the victim dies as a consequence, is liable for kidnapping with homicide and shall be penalized with the maximum penalty. In this case, notwithstanding the fact that the 1 week old child was merely kept in the attic of his house, gagged with stockings and placed in a box, sealed with tape, the deprivation of liberty and the intention to kill becomes apparent. Though it may appear that the means employed by past was attended by treachery, killing of an infant, nevertheless a separate charge of murder will not prosper in view of the amendment. Here, the term homicide is used in its generic sense and covers all forms of killing, whether in the nature of murder or otherwise. It is of no moment that the evidence shows the death of the child took place 3 minutes after the box was sealed, and the demand for the ransom took place in the afternoon. The intention is controlling here, that is, ransom was demanded. Crimes against property. Can there be a crime of robbery with attempted rape? The crime cannot be a complex crime or robbery with attempted rape under Article 48 because a robbery cannot be a necessary means to commit attempted rape, nor attempted rape to commit robbery. What is the criminal liability of a person who, on the occasion of a robbery, kills a bystander by accident? The person is liable for robbery with homicide because the revised penal code punishes the crimes as only one indivisible offense when a killing, whether intentional or accidental, was committed by reason or on occasion of a robbery. What is essential for a conviction for the crime of robbery with homicide? What is for the prosecution to establish the offender's intent to take personal property before the killing regardless of the time when the homicide is actually carried out. In cases when the prosecution failed to conclusively prove that homicide was committed for the purpose of robbing the victim, no accused can be convicted of robbery with homicide. People v. Chavez. Conspiracy in robbery with homicide. Fernandez opened the gate of Ana Lizo, trading without first checking who was knocking outside, thereby allowing Paris and his companions to freely enter the premises. Thereafter, Paris and his companions purposely proceeded directly to the room occupied by the victim Salvador. Paris and his companions did not harm Fernandez, despite the latter having already recognized or seen their faces. Instead, they went looking for Salvador, who was then asleep, and killed him. Fernandez directed Paris and his companions to the office of Ana. Fernandez did not offer any resistance, nor attempted to help Salvador. Fernandez did not do anything after seeing Paris and his companions leave Ana's office carrying a bag. Interestingly, he waited for more than 3 hours before informing his employers about the incident. Is Fernandez guilty of robbery with homicide? Yes. When there is conspiracy, the act of one is the act of all. Thus, when homicide is committed by reason or on occasion of robbery, all those who took part as principals in the robbery would also be held liable as principals on the single and indivisible felony of robbery with homicide, although they did not actually take part in the killing, unless it clearly appears that they endeavored to prevent the same. In the present case, both Fernandez and Paris were co-conspirators who are guilty of the special complex crime of robbery with homicide. Versus Paris. Klepto went alone to a high-end busy shop and decided to take one of the smaller purses without paying for it. Overcome by conscience, she decided to leave her own purse in place of the one she took. Her act was discovered and Klepto was charged with theft. She claimed that there was no theft, as the store suffered no injury or prejudice because she had left a purse in place of the one she took. Comment on her defense. The defense of Klepto has no merit. Theft is already consummated from the moment Klepto took possession of one of the smaller purses inside a high-end shop without paying for it. She took the personal property of another with intent to gain, without the consent of the latter. Damage or injury to the owner is not an element of theft. Hence, even if she left her purse in lieu of the purse she took, theft is still committed. When is the crime of theft qualified? 1. If theft is committed by a domestic servant. 2. If the theft is committed with grave abuse of confidence. Note: if the offense is to be qualified by abuse of confidence, The abuse must be grave, like an accused who was offered food and allowed to sleep in the house of the complainant out of the latter's pity and charity, but stole the latter's money in his house when he left the place. 3. If the property stolen is a motor vehicle, mail matter, or large cattle. If the property stolen consists of coconuts taken from the premises of a plantation. If the property stolen is fish taken from a fish pond or fishery. Or 6. If property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, and any other calamity, vehicular accident, or civil disturbance. Madam X, a bank teller, received from depositor Madam Y a check payable to cash in the amount of 1 million to be deposited to the account of Madam Y. Because the check was not a cost check, Madam X credited the amount to the account of her good friend Madam W by accomplishing a deposit slip. 7 days after, Madam X contacted her good friend Madam W and told her that the amount of 1 million was wrongfully credited to Madam W. Thus, Madam X urged Madam W to withdraw the amount of 1 million from her account and to turn over the same to Madam X. As a dutiful friend, Madam W readily acceded. She was gifted by Madam X with an expensive Hermes bag after the withdrawal of the amount. What crime, or crimes if any, did Madam X and Madam W commit? Madam X committed the crime of qualified theft under Article 310 RPC. When Madam X, a bank teller, received a check payable to cash in the amount of 1 million for deposit to the account of Madam Y, what was transferred to her was merely the physical or material possession thereof. Hence her subsequent misappropriation of the amount shall constitute theft, qualified by grave abuse of confidence. There is grave abuse of confidence because the relationship of guardianship, dependence, and vigilance between the depositor and the bank created a high degree of confidence between them, which Madam X, as the bank teller representing the bank, abused. What does fraud and deceit in the crime of estafa mean? In Alcantara v. CA, the court citing People v. Plaza explained the meaning of fraud and deceit, viz. Fraud in its general sense is deemed to comprise anything calculated to deceive, including all acts, omissions, and concealment involving a breach of legal or equitable duty, trust or confidence justly reposed, resulting in damage to another, or by which an undue and unconscientious advantage is taken of another. It is a generic term embracing all multifarious means which human ingenuity can devise, and which are resorted to by one individual to secure an advantage over another by false suggestions or by suppression of truth, and includes all surprise, trick, cunning, dissembling, and any unfair way by which another is cheated. Deceit is the false representation of a matter of fact, whether by words or conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives or is intended to deceive another, so that he shall act upon it to his legal injury. Latea v. People. Separate charges for estafa and illegal recruitment. It is settled that a person may be charged and convicted separately of illegal recruitment under Republic Act No. 8042 in relation to the Labor Code, and estafa under Article 315, Paragraph 2, letter A of the Revised Penal Code. The court explicated in People v. Cortez and Yabut that in this jurisdiction it is settled that the offense of illegal recruitment is malum prohibitum, where the criminal intent of the accused is not necessary for conviction, while estafa is malum in se, where the criminal intent of the accused is crucial for conviction. Conviction for offenses under the Labor Code does not bar conviction for offenses punishable by other laws. Conversely, conviction for estafa under Paragraph 2, letter A of Article 315 of the Revised Penal Code does not bar a conviction of illegal recruitment under the Labor Code. It follows that one's acquittal of the crime of estafa will not necessarily result in his acquittal of the crime of illegal recruitment in large scale, and vice versa. People v. Ochoa. Solina met with 7 people and gave the impression that she had the capability to facilitate applications for employment as factory workers in Japan in lieu of a fee amounting to 20,000. These people believed Solina, paid the said amount. However, no such promise materialized, and the money taken as a fee was never returned. Is Solina guilty of the crime of illegal recruitment in large scale, as well as Mustafa under Article 315? Yes, Solina is guilty of the crime of illegal recruitment in large scale, as well as Mustafa under Article 315 of the RPC. It is settled that a person may be charged and convicted separately of illegal recruitment under RA 8042 and Mustafa under 315 paragraph 2 of RPC. In this case, all the elements of the crime of illegal recruitment in large scale are present. 1. The offender has no valid license or authority required by law to enable him to lawfully engage in recruitment and placement of workers. 2. The offender undertakes any of the activities within the meaning of recruitment and placement under Article 13b 14 of the Labor Code, or any of the prohibited practices enumerated under Article 34 of the said code. Now Section 6 of RA 8042. And 3. The offender committed the same against 3 or more persons individually or as a group. Likewise, Solina is also liable for his stuff under Article 315, paragraph 2, letter A of the RPC, when she defrauded the private complainants into believing that she had the authority and capability to facilitate applications for employment as factory workers in Japan in lieu of a fee amounting to 20,000 pesos, in which the complainants complied with, resulting to their own damage and prejudice when such promise for employment never materialized. People versus Solina. Ernesto Pidelli assisted his brother Wilson and his business partner Placido Cancio in purchasing construction materials for a project by allowing them to use his credit line in Mount Trail Farm Supply in Hardware, MTFSH. At the completion of their project, the business partners Wilson and Cancio heeded to the advice of Ernesto that their net income of 130,000 should be applied first to settle their balance to MTFSH, and they entrusted the entire amount to Ernesto, with express instruction to pay MTFSH and deliver the remaining balance to them. Afterwards, Ernesto refused to give Cancio his share in the net income despite the latter's repeated demands. Is Ernesto guilty of theft or estafa? Ernesto is guilty of theft, not estafa. The court has consistently ruled that not all misappropriation is estafa. The principal distinction between the two crimes is that in theft, the thing is taken, while in estafa, the accused receives the property and converts it to his own use or benefit. However, there may be theft even if the accused has possession of the property. If he was entrusted only with the material or physical or de facto possession of the thing, his misappropriation of the same constitutes theft, such in the case of bar. But if he has the juridical possession of the thing, this conversion of the same constitutes embezzlement or estafa. Pidelli versus People. Carganillo was alleged to have entered a kasunduan with Teresita Lazaro, a rice trader in Nueva Ecija. Teresita gave the accused 132,000 pesos for the purpose of buying palay to be delivered on or before November 28, 1998 to Lazaro Palay buying station. In their kasunduan, the parties agreed that for every kilo of palay bought, the petitioner shall earn a commission of 20 centavos, but if no palay is purchased and delivered on November 28, the petitioner must return the 132,000 to Teresita within 1 week after November 28. However, no palay was received on the agreed day, and the 132,000 was never returned. Then Teresita made oral and written demands to the petitioner for the return of the 132,000, but her demands were simply ignored. Is Carganillo guilty of the crime of estafa? Yes. All elements of estafa are present. First, that money, goods, or other personal property is received by the offender in trust or on commission, or for an administration or under any other obligation involving the duty to make delivery or to return the same. The petitioner received in trust the amount of 132,000 from Teresita for the purpose of buying Palay. Second, that there be misappropriation or conversion of such money or property by the offender, or denial on his part of such receipt. There was misappropriation when petitioner failed to confirm in their kasunduan not delivering the agreed palay nor returning the 132,000 pesos for such failure of delivery of palay. Third, that such misappropriation or conversion or denial is to the prejudice of another. The acts of petitioner were to the prejudice of Teresita. Lastly, that there is demand by the offended party to the offender. Teresita demanded for the return of the 132,000, and this was shown in her oral and written demands to the petitioner. Carganillo versus People. Madarang went to Villanueva's residence and was able to sell to Villanueva 5 cents of jewelry. Villanueva made out 9 checks, 8 of which were post-dated for the payment of such jewelries. Madarang received the checks because of Villanueva's assurance that they would all be honored upon presentment. However, the jewelry bank paid only one of the 8 post-dated checks, since the remaining checks were dishonored on account of insufficient funds and account closed. Is Madarang liable for estafa? Yes. All the elements are present, in which the first element was admitted by Villanueva, who confirmed that she had issued the checks to Madarang in exchange for the jewelry she had purchased. There is no question that Madarang accepted the checks upon the assurance of Villanueva that they would be funded upon presentment. The second element was likewise established because the checks were dishonored upon presentment due to insufficiency of funds or because the account was already closed. The third element was also proved by the showing that Madarang suffered prejudice by her failure to collect from Villanueva. People versus Villanueva. Sato, through fraudulent misrepresentations, was able to secure the signature and thumb mark of Monolita Gonzalez on a special power of attorney, where his daughter is made attorney in fact, and sold 4 valuable pieces of land in Tagaytay City. Estafa under Article 315, Paragraph 3 was filed against him in the RTC. Sato moved for the acquisition of the information, claiming that under Article 332, his relationship with Monolita Gonzalez, his mother-in-law, was an exempting circumstance. Is Sato exempted from criminal liability under Article 332 for the complex crime of estafa through falsification of public documents? No. Sato is not exempted from criminal liability under Article 332 for the complex crime of estafa through falsification of public documents. The absolutory cause under Article 332 is meant to address only simple crime of theft, swindling, and malicious mischief, when the offender resorts to an act that breaches the public interest in the integrity of public documents, as to violate the property rights of a family member. He is removed from the protective mantle of the absolutory cause under Article 332, intestate estate of Monolita Gonzalez. Crimes against chastity. Elements of adultery. To convict a woman for adultery, it is necessary that a. She is a married woman, and b. That she unites in sexual intercourse with a man not her husband. 2. To convict a man for adultery, it is necessary that a. He had actual intercourse with a married woman, and b. That he commits the act with the knowledge that said woman is married. Note: adultery as to the male sexual partner of the married woman. Elements of concubinage. Number 1. Man must be married. 2. He committed any of the following acts: a. Keeping a mistress in the conjugal dwelling. b. Having sexual intercourse under scandalous circumstances with a woman who is not his wife. Or c. Cohabiting with her in any other place. 3. As regards the woman, she must know him to be married. AAA was about to enter the school campus with her friend when Kayanan, her brother-in-law, arrived in a tricycle and pulled AAA towards the tricycle. She tried shouting, but Kayanan covered her mouth. Kayanan brought AAA to a dress shop to change her clothes, since she was in her school uniform, and later to a Jollibee outlet. Afterwards, he brought her to his sister's house and raped her inside a bedroom. AAA told her mother and brother of the incident, and she was shown to be suffering from depressive symptoms and presence of sexual abuse. Kyanan interposed the sweetheart defense and presented two love letters supposedly written by AAA. The RTC and CA convicted Kyanan of forcible abduction with qualified rape. Is Kyanan guilty for the crime of forcible abduction with qualified rape? No. Kyanan should only be liable for qualified rape. Forcible abduction is absorbed in the crime of rape if the real objective of the accused is to rape the victim. In this case, circumstances show that AAA's abduction was with the purpose of raping her. People versus Kyanan. Crimes against civil status. A contracted a second marriage while having a subsistent and valid first marriage. The first marriage was declared void ab initio. Subsequently, A was charged with the crime of bigamy. A contends that the information on bigamy must be quashed on the ground that there was a declaration of nullity on the previous marriage prior to the filing of the action. Is A's contention correct? No. The contention of A is wrong. It has been clarified in the Family Code and has been held in a number of cases that a judicial declaration of nullity is required before a valid subsequent marriage can be contracted. What makes a person criminally liable for bigamy is when he contracts a second or subsequent marriage during the subsistence of a valid marriage. Well settled is the rule that criminal culpability attaches to the offender upon the commission of the offense, and from that instant, liability appends to him until extinguished as provided by the law, and at the time of filing of the criminal complaint or information is material only for determining prescription. People versus Odtuhan. Bitancol married Alice Eduardo and begot 3 children. After some time, Alice began hearing rumors that her husband was previously married to another woman named Gina Gerlan. Such marriage was supported by a marriage contract registered in the NSO. This prompted Alice to file a criminal complaint for bigamy against Bitancol. In his defense, Bitancol alleged that he already revealed to Alice that he had a fake marriage with his college girlfriend Gina, and that there is a certification from the Office of the Civil Registrar that there is no record of the marriage issued to Bitancol and his first wife Gina, which makes his first marriage as void. Is Bitancol liable for the crime of bigamy? Yes. Bitancol is liable of the crime of bigamy. Bigamy consists of the following elements. 1. That the offender has been legally married. 2. That the first marriage had not yet been legally dissolved, or in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the Civil Code. 3. That he contracts a second or subsequent marriage. And 4. That the second or subsequent marriage has all the essential requisites for validity. In this case, all the elements of bigamy are present, since Bitancol was still legally married to Gina when he married Alice. His defense of certification from the Office of the Civil Registrar implying that there is no record of the marriage licensing issued to Bitancol and his first wife Gina will not lie, since marriages were not dissolved through mere certifications by the Civil Registrar. Hence, Bitancol is still considered to be legally married to Gina when he married Alice and is not exculpated from the bigamy charge. People versus Bitancol. Maine was validly married to Lico on June 1, 2015. Lico, however, died a month after the celebration of their marriage. 3 months after the death of her husband, Maine found another love of her life in the name of Darnie. They eventually fell in love with each other. Darnie married Maine on October 3, 2015. Is Maine liable for any crime? No. RA 10655, March 13, 2015, decriminalized the act of premature marriage. Article 1st of the said law provides that without prejudice to the provisions of the Family Code on Paternity and Filiation, Article 351 of Act No. 3815, otherwise known as the Revised Penal Code, punishing the crime of premature marriage committed by a woman, is hereby repealed. Crime against honor, true or false, and the crime of libel, treated as an absolute defense. False. Article 361 of the RPC provides that proof of truth shall be admissible in libel cases only if the same imputes a crime or is made against a public officer with respect to facts related to the discharge of their official duties, and moreover, must have been published with good motives and for justifiable ends. Hence, truth as a defense on its own is not enough. X was charged with the crime of libel. In his defense, he contended that he should not be liable for the crime of libel because there is no malice, in fact, proven by the prosecutions, since he is merely a responding urban poor leader acting as counsel, defending a member of an association under threat of ejectment from her dwelling place, and thus should be considered as privileged communication. X also contends that there is no proper publication, since the libellous remarks were only made in a private correspondence. Are the contentions of X correct? X is criminally liable for the crime of libel. When the imputation is defamatory, the prosecution need not prove malice on the part of X, malice in fact, for the law already presumes that his imputation is malicious, malice in law. There is publication when that same letter was furnished to all those concerned. A written letter containing libelous matter cannot be classified as privileged when it is published and circulated among the public. Boatis versus People. Alexis filed an action for damages arising from libel and defamation against Alejandro on account of a published letter containing the following. This is to notify you and your staff that one Alexis Dodong, Almendras, a brother, is not vested with any authority to liaison or transact any business with any department, office, or bureau, public or otherwise, that has bearing or relation with my office, mandates, or functions. Noteworthy to mention, perhaps, is the fact that Mr. Alexis Dodong, C. Almendras, a renowned blackmailer, is a bitter rival in the just concluded election of 1995, who ran against the wishes of my father, the late Congressman Alejandro D. Almendras Sr. He has caused pain to the family when he filed cases against us, his brothers and sisters, and worse, against his own mother. I deem that his act of transacting business that affects my person and official functions is malicious in purpose, done with ill motive and part of a larger plan of harassment activities to perforce realize his egoistic and evil objectives. May I therefore request the assistance of your office in circulating the above information to concerned officials and Secretariat employees of the House of Representatives. Alejandro in his defense insists that he has the legal, moral, or social duty to make the communication, or at least had an interest to protect, being then a congressman duty-bound to insulate his office and his constituents from the dubious and mistrustful pursuit of his elder brother. Moreover, the letters were also not meant to be circulated or published. They were sent merely to warn the individuals of respondents' nefarious activities, and made in good faith and without any actual malice. Is Alejandro guilty of libel? Yes. Under Article 354, every defamatory imputation is presumed to be malicious, even if true, if no good intention and justifiable motive is shown. As an exception to the rule, the presumption of malice is done away with when the defamatory imputation qualifies as privileged communication. In order to qualify as privileged communication under Article 354, Number 1, the following requisites must concur. 1. The person who made the communication had a legal, moral, or social duty to make the communication, or at least had an interest to protect, which interest may either be his own or the one to whom it is made. 2. The communication is addressed to an officer or a board or superior having some interest or duty in the matter, and who has the power to furnish the protection sought. And 3. The statements in the communication are made in good faith and without malice. Alejandro's contention that he has the legal, moral, or social duty to make the communication cannot be countenanced, because he failed to communicate the statements only to the person or persons who have some interest or duty in the matter alleged, and who have the power to furnish the protection sought by the author of the statement. A written letter containing libelous matter cannot be classified as privileged when it is published and circulated among the public. Criminal negligence. What is reckless imprudence? Reckless imprudence consists in voluntary but without malice, doing or failing to do an act from which material damage results from reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. What is simple imprudence? Simple imprudence consists in the lack of precaution displayed in cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. Y, while alighting from his vehicle, was hit by X with his car. This caused Y to be thrown 4 meters away from his jeepney. X was charged with frustrated murder and convicted in the RTC of frustrated homicide. Upon appeal in the CA, the crime was modified to reckless imprudence resulting in serious physical injuries. X contends that he is not liable for such crime because he lacked criminal intent, that he was not negligent in driving his pickup truck, and that the CA should have appreciated voluntary surrender as a mitigating circumstance in his favor. Is X's contention correct? The contention of X is wrong. To constitute an offense of reckless driving, the act must be something more than a mere negligence in the operation of the motor vehicle, but a willful and wanton disregard of the consequences is required. The fact that Y's body was thrown 4 meters away from his jeep showed that X was driving his pickup at a fast speed when he overtook the jeep of Y. The mitigating circumstance of voluntary surrender cannot be appreciated in his favor. Paragraph 5 of Article 365 Revised Penal Code expressly states that in imposition of penalties, the courts shall exercise their sound discretion without regard to the rules prescribed in Article 64 of the Revised Penal Code. Mariano v. People. X, while descending from a curved path, collided with a motorcycle, killing Y, one of his passengers, and causing serious physical injuries to the 2 other victims. The body of Y was loaded to the vehicle of X, but the latter's engine would not start. Thus the body was loaded in a different vehicle. The jack of X was used to extricate the body of Y from being pinned under the vehicle of X. X, in his defense, claimed that it was not his fault that the tricycle swerved in his direction. X was charged with reckless imprudence resulting to homicide with double serious physical injuries and damage to property under Article 365. In relation to Article 263 of the RPC, with the aggravating circumstance that accused failed to lend on the spot to the injured party such help that it was in his hands to give. Should the court appreciate the alleged aggravating circumstance? No. The aggravating circumstance that accused failed to lend on the spot to injured party such help that it was in his hand to give should not be appreciated. Verily, it is an inexcusable lack of precaution or conscious indifference to the consequences of the conduct which supplies the criminal intent in Article 365. The limiting element in the last paragraph of Article 365 of the RPC, which imposes the penalty next higher in degree upon the offender who fails to lend on the spot to the injured parties such help as may be in his hands to give. According to case law, the following must be present to constitute the offense. A is dependent on the means in the hands of the offender. Example, the type and degree of assistance that he or she at the time and place of the incident is capable of giving, and B requires adequate proof. X was able to supply the help according to the extent of capabilities. Gonzaga v. People.